Grounds of restrictions on the freedom of speech and expression. Grounds of restrictions. Clause 2 of Article 19 contains the grounds on which restrictions on the freedom of speech and expression can be imposed. A. Security of the state. B. Friendly relations with foreign states. C. Public order. D. Decency of morality. E. Contempt of court. F. Defamation. G. Incitement of an offense. H. Sovereignty and integrity of India. A. Security of the state. Under Clause 2 of Article 19, reasonable restrictions can be imposed on freedom of speech and expression in the interest of security of the state. In Romesh Thapar vs. State Madras, AIR 1950, the Supreme Court has occasion to interpret the meaning of the words security of the state. The court said that there are different grades of offenses against public order. Every public disorder cannot amount to be regarded as threatening the security of the state. The term security of the state refers only to serious and aggravated forms of public disorder, example, rebellion, waging war against the state, insurrection, and not ordinary breaches of public order and public safety, example, unlawful assembly, riot, affray. Thus, speeches or expression on the part of an individual which incite to or encourage the commission of violent crimes, such as murder, are matters which would undermine the security of the state. The words "in the interests of" before the words "security of the state" clearly imply that the actual result of the act is immaterial. Thus, acts which may indirectly bring about an overthrow of the state would come within the expression. An incitement to an armed revolution, though infructuous, ultimately is enough to attract the term security of the state. B. Friendly relation with foreign states. This ground was added by the Constitution, First Amendment, Act, 1951. The object behind the provision is to prohibit unrestrained malicious propaganda against a foreign friendly state which may jeopardize the maintenance of good relations between India and that state. No similar provision is present in any other constitution of the world. But the laws of each country have adequate provisions to safeguard peaceful relations with foreign states. In India, the Foreign Relations Act, 12 of 1932, provides punishment for libel by Indian citizens against foreign dignitaries. Again, the Foreign Recruiting Act, 4 of 1874, empowers the executive to prohibit recruitment of any citizen of India to the army of foreign states. But the interests of friendly relations with foreign states would not justify the suppression of fair criticism of foreign policy of the government. It is to be noted that members of the Commonwealth, including Pakistan, is not a foreign state for the purposes of this constitution. The result is that freedom of speech and expression cannot be restricted on the ground that the matter is adverse to Pakistan. C. Public order. This ground was added by the Constitution, First Amendment, Act, 1951, in order to meet the situation arising from the Supreme Court's decision in Romesh Thapar's case. In that case, it was held that ordinary or local breaches of public order were no grounds for imposing restriction on the freedom of speech, expression guaranteed by the Constitution. The Supreme Court said that public order is an expression of wide connotation and signifies that state of tranquility which prevails among the members of political society as a result of internal regulations enforced by the government which they have established. In that case, the Supreme Court struck down a law banning the entry of a journal in the state of Madras in the interest of public order because Article 19, 2 did not contain the expression public order. It was held that restrictions could only be imposed on the grounds mentioned in Article 19(2). As a result of this decision, the expression public order was added to Article 19(2) as one of the grounds for imposing restrictions on the freedom of speech and expression. D. Decency or morality. The words morality or decency are words of wide meaning. The word obscenity of English law is identical with the word indecency under the Indian Constitution. The test of obscenity is whether the tendency of matter charged as obscene is to deprave and corrupt those whose minds are open to such immoral influences and into whose hands a publication of this sort is likely to fall. Thus, a publication is obscene if it tends to produce lascivious thoughts and arouses lustful desire in the minds of substantial numbers of that public into whose hands the book is likely to fall. This test was laid down in an English case of R versus Hicklin. Sections 292 to 294 of the Indian Penal Code provide instances of restrictions on the freedom of speech and expression in the interest of decency and morality. These sections prohibit the sale or distribution or exhibition of obscene words, etc. in public places. But the Indian Penal Code does not lay down any test to determine obscenity. In Ranjit D. Udeshi vs. State of Maharashtra, AIR 1965, the Supreme Court accepted the test laid down in the English case of R vs. Hicklin to judge the obscenity of a matter. In this case, the court upheld the conviction of the appellant, a bookseller, who was prosecuted under Section 292 IPC for selling and keeping the book, The Lady Chatterley's Lover. Applying the above test, the court held the novel as obscene. It has rightly been submitted that the court has erred in not rejecting Hicklin rule, which has become obsolete. It lays down a vague and arbitrary standard for judging obscenity and has a tendency to curtail the guaranteed right to freedom of speech. No fixed standard can be laid down as to what is moral and indecent. The standard of morality varies from time to time and from place to place. Birth control, which was once considered immoral, is not considered proper as a means to check overpopulation. On these considerations, we may submit that the court should revise its opinion as soon as it get an opportunity to do so and reject the rule laid down nearly 100 years ago by an English judge. E. Contempt of court. Restriction on the freedom of speech and expression can be imposed if it exceeds the reasonable and fair limit and amounts to contempt of court. F. Defamation. A statement which injures a man's reputation amounts to defamation. Defamation consists in exposing a man to hatred, ridicule or contempt. In India, Section 499 of the I.P.C. contains the criminal law relating to defamation. It recognizes no distinction between the defamatory statement addressed to the ear or eyes, that is, slander and libel. These sections are saved as being reasonable restrictions on the freedom of speech and expression. The civil law relating to defamation is still uncodified in India and subject to certain exceptions follows generally the English law. G. Incitement to an offence. This ground was also added by the Constitution, First Amendment, Act, 1951. Obviously, freedom of speech and expression cannot confer a license to incite people to commit offense. The word offense used here is not defined in the Constitution. It is, however, defined in the general clauses as meaning offense shall mean any act or omission made punishable by any law for the time being in force. What constitutes incitement will, however, have to be determined by the court with reference to the facts and circumstances of each case. H. Integrity and sovereignty of India. This ground was added to Clause 2 of Article 19 by the Constitution, 16th Amendment, Act, 1963. Under this clause, freedom of speech and expression can be restricted so as not to permit to anyone to challenge the integrity or sovereignty of India or to preach cession of any part of India from the Union. It is to be noted that sedition is not mentioned in Clause 2 of Article 19 as one of the grounds on which restriction on freedom of speech and expression may be imposed. As understood in English law, sedition embraces all those practices whether by word or writing which are calculated to disturb the tranquility of the state and lead ignorant persons to subvert the government. Thus the gist to the offence of sedition is incitement to violence. Mere criticism of the government is no offence. In India, Section 124- of the Indian Penal Code defines the offence of sedition as follows: whoever by words either spoken or written, or by signs, or by visible representation or otherwise brings or attempts to bring into hatred or contempt or attempts to excite disaffection towards the government established by law in India shall be punished. Explanation 3 to Section 124- states that mere comment expressing disapprobation of government is no offence if it does not excite or attempt to excite disaffection towards government established by law.